Good afternoon. Welcome to this afternoon's Business in 2021 webinar presentation. My name is Kathy Purdy, and I'm a marketing manager here at Bond. Just two quick housekeeping items to go over before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows. Once the webinar has ended, we would appreciate you taking a moment to complete the brief survey. Your comments and suggestions are important to our panelists and provide us with topics for future presentations. It is now my pleasure to introduce today's moderator, Adam Masterleo.
Kathy, thank you so much, and welcome to all of you who are joining us this Tuesday. There is a lot going on and we have a lot to talk about. Before we get into the first topic, I just wanted to comment on something, an observation of how quickly things change in the world of COVID and COVID restrictions and protocols. The last time I was on this webinar was 2 weeks ago. One of the presentations I provided was on the three different federal vaccine mandates. You have the federal contractor mandate, the CMS mandate, and the Osha emergency temporary standard. At the time of my presentation, the Osha emergency temporary standard and the CMS vaccination mandate had been put on a nationwide stay by federal courts, and the federal contractor mandate was only stayed in a couple of select states. 2 weeks later, and we have significant changes. We have the CMS vaccine mandate still on a nationwide stay. We have the federal contractor mandate on a nationwide stay, and that will turn us right into our first topic of the day. And that is going to be the OSHA emergency temporary standard, because there have been significant developments with that rule in the past week. So here to talk to us about that is someone who you've seen on this webinar a number of times, talking to us about OSHA and all the wonderful things that OSHA does. So here to do that is Mike Billick. Mike is a partner in our Saratoga office. So Mike, please take it away.
You got it. Yeah, I've been practicing OSHA law for 15 years and have never had any excitement over OSHA, shall we say, or at least OSHA press like there has been over the past few months for obvious reasons. So get right into it. Wake up Saturday morning to the news that the Sixth Circuit lifted the stay that was imposed by the Fifth Circuit. So just to give you a recap, the Fifth Circuit issued a nationwide stay of the OSHA rule. And then there were a number of cases that were filed in various circuit courts across the country. And those cases were consolidated into one circuit that was chosen at random by lottery, and that was the Sixth Circuit. So there's only the one consolidated case taking place right now in the Sixth Circuit. So the Sixth Circuit lifting the stay, there is not another circuit court that is going to rule on this issue. And of course, you're saying, Mike, you predicted this rule would be stayed. What happened? Well, I still think it'll be stayed. We'll talk about that. But what happened was two judges of the Sixth Circuit have. There were various motions for the Sixth Circuit to hear this case en banc, for all of the judges in the Sixth Circuit to hear it. That was denied. And so just a panel of 3 judges heard it, with 2 judges agreeing to lift the stay and 1 judge dissenting. Now, in the opinion that lifted the stay, I'll just read a couple sentences, and it's one of those things where you see if you agree with these things or not. One is, OSHA's issuance of the ETS is not an enormous expansion of its regulatory authority. Another sentence is, the ETS regulates employers of more than 100 employees, not individuals. Well, you tell that to about the 2/3 of working individuals in the country that do work for large employers. So overall, the opinion lifting the stay, it really just says, OSHA, we believe you. We agree with all the reasons that you have set forth as to why you've issued the rule. What's interesting is the dissent in the case, and a lot of times when cases go up to the Supreme Court, more on that in a second, the dissent in a circuit court case provides a little bit of a roadmap in terms of what the Supreme Court may decide to follow. And there's very interesting in that Judge Larson focuses on the fact that OSHA never actually made a finding in the preamble to the rule that it's required to do in order to issue an emergency standard, that the standard was necessary. He says, yeah, all these things that OSHA is saying, they can be helpful, but there's nothing in here in terms about why issuing this standard, these requirements at this time was necessary to save lives as required to forego notice and comment rulemaking. He also really takes a sledgehammer to OSHA's grave danger argument, saying that, well, the majority of employees in these workplaces are vaccinated, so they're not in grave danger. Likewise, if you're talking about younger unvaccinated employees in their late teens and 20s, they have the same COVID risk as older vaccinated adults. So OSHA can't necessarily find that they're in grave danger. And then he also cites the Supreme Court's recent holdings in, you may recall, the CDC enacting that national eviction moratorium. The Supreme Court at first said, okay, we'll allow it to be in place for a little bit longer, and then it came back once it was renewed to the Supreme Court, and the Supreme Court said, no, the CDC does not have this power. And from that decision, there's some quotes from the Supreme Court's decision that Judge Larson, his dissent quotes here, that that Congress has to, quote, speak clearly if it wishes to assign to an agency like OSHA decisions of vast economic and political significance. And the Supreme Court will, quote, be skeptical when an agency suddenly discovers in a long extant statute an unheralded power to regulate a significant portion of the American economy. Okay, so Mike, what now? Well, a number of plaintiffs have petitioned the Supreme Court for an emergency stay of OSHA's rule. Now, the rules for a stay are interesting because in order for the Supreme Court to take a case, just generally speaking, 4 justices have to say, yeah, we'll consider this case. In order for there to be a stay, 5 justices have to agree that this case will be stayed. Well, in that CDC eviction moratorium case, there was recently an application for that to be stayed, and only Justice Breyer dissented from that case that would have allowed the eviction moratorium to remain in place during the appeal. So that's some reading of the tea leaves. Everybody's reading tea leaves here. I think everybody, in terms of the legal scholars that I've seen, and based on how they ruled in the Maine and New York healthcare vaccine cases, Justices Gorsuch, Thomas, and Alito would definitely vote in favor of taking this case for certiorari as well as for a stay. Remains to be seen if Justices Kavanaugh, Barrett, and the Chief Justice Roberts would agree to do so. I do think, given the constitutional issues, that they would. In order for them to do so, they have to find that there's a reasonable probability that 4 justices would grant certiorari, that there's a fair prospect that a majority of the court would conclude that the decision below not granting the stay was erroneous, and that irreparable harm will result in these businesses and the employees in these businesses that would result in the denial of the stay. So my own personal opinion, I think that they will. In the meantime, the government has until December 30th to respond. It's a bit of a long deadline. A lot of times in these cases, the opposing party may only have a few days, so they have until December 30th to respond, which means that the court is not going to rule on this until likely very early in the new year, and the week of January 3rd. Well, so what to do? OSHA has said it will hold off on enforcement of this rule for the time being for a few weeks. So, and there's 2 deadlines that OSHA has set. The first is for everything other than actually testing unvaccinated employees. That deadline, OSHA will start enforcing that February 9th. Before then, OSHA said it will hold off enforcement until January 10th for the other provisions of the rule. And Adam will talk more about the details of these provisions, establishing a policy, determining the vaccination status of each individual, and in terms of removing any employees from the workplace as required, the support for them to the extent that that they go to get vaccinated. And some of these things you're doing already, of course, given New York's requirements for allowing time off for vaccination, and of course the current order for masking. One thing I will say is that with February 9th, that deadline for implementing the vax or test rule, that's the one time where OSHA says you don't have to test employees who are quote unquote fully vaccinated. If an employee gets their first shot of, or one and only shot of Johnson & Johnson on February 9th, or they get their second shot of Pfizer, Moderna, February 9th or beforehand, you don't have to test those employees for the first 2 weeks while they become fully vaccinated, that 2-week time period. But that's the only time that'll happen. Any other time after that, if an employee gets their second shot of a 2-dose vaccine or gets a shot of Johnson & Johnson, they would need to be tested during that 2-week period before they're fully vaccinated. So, a few days ago, and I was asked, what do we do? Do we work to comply with this? I said, well, give it a few days. Well, it's been a few days, and we now know what when the government's deadline is, and approximately when the Supreme Court will rule on this. I'm still thinking the Supreme Court is going to grant the stay. So it's sort of a cautious waiting game. I would be ready and to implement your policy as need be by the middle of the week, January 3rd, by say the 5th, 6th, or 7th, and be ready to get that information from employees about whether they're vaccinated or not. But it's one of those waiting patiently until you see the whites of their eyes. We should see the Supreme Court's decision by early that week to decide, okay, is this something where they are going to stay enforcement of the rule, or we'll have the certainty that the rule will be going into effect while this is being litigated. So, and that's all I have.
Mike, thank you very much. All right, to sum up, we had a question in the Q&A about what a stay is. So just to sum up, for right now, the OSHA ETS is in effect. The current, right?
Correct.
All right, and we're waiting.
It's in effect, but OSHA has said it won't enforce it. It won't issue any citations. It won't inspect for it until January 10th for everything other than the RU testing employees who are not fully vaccinated. That will start February 9th.
Perfect. All right, and in the meantime, if an employer is concerned, there are a couple things they can start to do. One being put your policy together. There are templates online on the OSHA website, both the VAX policy and the VAX tester mask policy. So get your policy ready. 2, you can start developing your roster of vaccinated employees if you haven't done that already. Those are a couple of things you can do. If you need to put them in place, you put them in place. If not, you just have them.
Correct.
Okay, great. All right, Mike. Well, thank you so much. Really appreciate it. That's great. And we will keep everyone up to date on any new developments relating to this vaccine mandate. Okay, next up, we are going to turn to a topic we haven't talked about much, but that there are some updates regarding. And so we thought it would be a good idea to give you some information about this. Here to present today about eviction and the eviction and foreclosure moratorium updates are Sarah Temis, who's a partner in our bankruptcy department here in Syracuse, and Jeff Eaton, who also works in our Syracuse office. So Sarah, with that, I'll turn it over to you.
All right, great. Thanks, Adam. As Adam said, I'm a member in our business restructuring and bankruptcy group, and Jeff is one of our senior associates, and he has a significant amount of experience in both bankruptcy and real property law. And Jeff will get us started.
Thanks, Sarah. Thanks for joining us, everyone. I wanted to give an update on the most recent iteration of the eviction and foreclosure moratorium that's been put in place by Governor Hochul. It was signed into law September 2nd of this year and is scheduled to go until January 15th of 2021. Now, what does that mean, a moratorium? Essentially, it will prevent most eviction and foreclosure proceedings, but which ones it'll prevent, I'll get to in just a minute. But ultimately, these would be paused until January 15th of 2022. So realistically speaking, Sarah and I both expect that January 15th, 2022 date is fluid. It will probably be extended at least, once or twice more, but until it does, we're going to go with that date, January 15th, 2022, and we won't be surprised if they do extend that. So the specifics, the moratorium is going to stay certain commercial real property mortgage foreclosure actions, specifically actions involving a mortgagor owning 10 or fewer commercial units and employing 100 employees or fewer. It's also going to apply to residential tenants and certain commercial tenants. So it will prevent a foreclosure or an eviction from going forward on those. In order for the tenant or the mortgagor to take advantage of this protection under the law, they're going to need to submit a declaration of hardship during the COVID-19 pandemic. It's a form, it's been put together by the courts, and it's a pretty basic form. It's available in a number of different languages. And if you are trying to pursue a foreclosure or an eviction, you actually need to provide that form to the person you're trying to take out of possession. And if they return it to you, then they're going to get to take advantage of this current moratorium and you won't be able to evict or foreclose until the moratorium ends. This iteration of this has been around in one form or another for basically the entirety of the COVID-19 pandemic. But this iteration of the moratorium is a little different than previous ones in that they've added some guidance to respond to the Chrysalis versus Marks Supreme Court decision, which will allow a landlord or a mortgagee to contest the hardship. So if they file a hardship form, a COVID-19 hardship form, the landlord or mortgagee could, in fact, challenge the hardship and say, wait a minute, they filled this out, but there isn't actually a hardship here. We deserve to be able to go forward and take possession of this property. But, it's not an easy burden for a landlord or a mortgagee to do this. It's a rebuttable presumption, but there is a presumption that anyone who files a COVID-19 hardship form would in fact be experiencing a COVID-19 hardship. So, the evidentiary burden to overturn that is steep. However, speaking specifically about landlords can continue to evict tenants who are creating a health or safety hazard for other tenants, intentionally damaging the property, or where a tenant doesn't file a hardship declaration. So if you provide it to the tenant and they don't fill it out, then the hardship, then the moratorium doesn't essentially protect that tenant. So that's sort of the basics about the current iteration of the moratorium. I think it makes sense to look forward, planning, how should a landlord or a mortgagee plan for the end of this moratorium, whether it's January 15th of 2022 or another date to be determined. And when you're looking at a commercial foreclosure, there's going to be a significant backlog in the courts whenever they do restart these foreclosures. So, you need to be prepared for, it will take a while before you're going to be able to get your day in court on something like this. Additionally, a mortgagor, someone who's in possession of a property may be planning to file a Chapter 11 bankruptcy to protect themselves whenever this moratorium does cease. With respect to landlord and tenants, a situation where hardship's declared, the landlord should be planning for an eventual end to the moratorium especially where there's a significant amount of unpaid rent. If it's not just that they have a couple of months that they fell behind, if they fell behind 6, 7, 8, 9 months worth of rent, the landlord should be looking forward proactively where they can. If there is an outstanding balance of rent that's past due, you can reach, a landlord can reach out to the tenant and potentially seek to renegotiate the lease, sort of term out some of that past due rent, either monthly or to the end of the lease, if that's something you think that will benefit you. If the original lease that we're talking about here was not secured by a personal guarantee by one of the principals or owners of the business, certainly it would be a good idea during any such renegotiation to get that extra protection, to get a personal guarantee, so that if the business itself is failing, you have another layer, you have another option to pursue your remedies against. In addition, as part of that renegotiation, a landlord should, 100 times out of 100, if you don't have the right to do a walkthrough to take a look at the premises, you want to get an inspection before you sign any renegotiation. You want to make sure that there's no damage, that the tenant isn't damaging the premises, because one, it would allow you to evict them immediately, regardless of a COVID, hardship, because there's damage to the property. But two, you want to make sure that if you're going to renegotiate this lease and term out any past due rent, that the premises itself is not being damaged or neglected in any way. Now, while the moratorium prevents an eviction, it doesn't prevent a landlord from exercising other rights under the law, including a termination of the lease. If you were to terminate a lease, one benefit would be that if the tenant subsequently filed for bankruptcy, they would have less remedies, less options available to them in bankruptcy. Bankruptcy cannot resurrect a lease that ends up being terminated. So if you're renegotiating, well, the tenant, if they filed bankruptcy, would have all of their rights under bankruptcy. If you terminated the lease prior to that tenant filing for Chapter 11 protection, their options are far more limited. Additionally, if the landlord has a personal guarantee already, or a corporate parent guarantee, you can start you can seek a money judgment on that now. You don't have to wait until the moratorium ends to do that. It's not taking them out of possession. It's simply getting paid what you're owed. And just sort of one sort of closing, piece of advice, if possible and if reasonable. And what I mean by that is, if it works for you, if it works for you as a landlord, if it works for your business, a landlord should be looking to work, or at least engage in a dialogue with the tenant prior to the expiration of the moratorium, because you're going to be able to have a better idea whether you can be flexible, whether there is some wiggle room to renegotiate, whether there is a way to continue this relationship, prior to that moratorium ending. It's far easier and better for you to be looking at this proactively than, the moratorium ends and you're behind the 8 ball and you need to make a decision quickly. What do I do? Do I evict or do I not evict? So it's always better to be having these discussions proactively, where the tenant or where the mortgagee will engage in them. So I think with that said, I'm going to turn it over to Sarah for the second half of the presentation.
Sure, and I'll try to go quickly. I think we're running over our time a little bit, but I'm happy to give a little bit of an idea of what happens when a bankruptcy case is filed. And we think this is quite likely for tenants and for mortgagors that are way behind. Once they get to the point where their backs are sort of pushed against the wall and this moratorium is removed, we think that there'll be a number of bankruptcy filings. We've gotten a lot of calls from clients who are concerned because they're in a business relationship with an entity that they know is either tripped a covenant or has another major issue, or a supplier or a vendor, where they're concerned about a bankruptcy filing. But just in the lease and real property mortgage arena, two things to note. First is that there's an automatic stay that's in place. A landlord or a mortgagee can't try to collect during the early stages of a bankruptcy case, or really at all without court approval. And that happens both for landlords and mortgagees, and prevents any further action to assert pre-petition rights just generally. And then next, in the lease context, when a bankruptcy case has been filed, there's a short period of time, 120 days from the filing of the bankruptcy case, where the tenant has to decide whether or not they're going to assume or reject the lease. So if they decide to assume the lease, they've got to cure all the defaults. So including all of this rent backlog that's been happening over the past many months in certain cases, they have to cure all the pre-petition defaults in order to assume the lease. If they want to reject the lease, it'll trigger a rejection damages claim, which will be a sort of portion of the remainder of the lease obligation that's owed. So those are a couple issues to think about when you're looking at a tenant bankruptcy. In a commercial foreclosure situation where those are restarting in a mortgagor files a bankruptcy case, when there's been a major default, you have to. That the mortgagee is in a situation in that case where they can assert rights for adequate protection and get payments very, very quickly out of the box, especially if they're undersecured. They can try to go in and try to renew payments going forward under the mortgage. When a business primarily operates as the owner of real estate, if it doesn't do anything else, if it's a business that is an income-producing property and that business entity itself is the entity that is the mortgagor, it could be designated by a bankruptcy court as a single asset real estate debtor, and they have to go more quickly in terms of filing a plan and commencing payments to the secured creditor. They won't get the benefit of a lengthy automatic stay to prevent a foreclosure or to prevent the secured lender retaking the property. So just super quickly, when should you reach out to our group? I guess, the best time to reach out is when there's a major default on the horizon, or now when legal proceedings could be commenced or continued, in the near future when this moratorium ends, in New York at least. The more time we have to assess the situation and offer alternatives to restructure any of these obligations, the better the chances are of avoiding any major issues in a bankruptcy case. So, sorry I went so quickly. I tried to talk quickly to get a lot in, but I'm happy to also answer questions.
Sarah, there's a lot there, so don't apologize. And if anybody on today has any more questions about the topics discussed by Sarah or Jeff, please feel free to reach out to them. They'll be happy to talk to you. Okay, next up, we're going to turn to New York City. We had heard that a vaccine mandate was coming, and then the vaccine mandate and some FAQs were finally released. So here to talk to us today about that is Michael Collins. He's a partner in our White Plains office, and he also works in our Manhattan office. So Mike, please take it away.
Good afternoon, folks. So I'm going to speed through this because there's some basic but important points. An order was issued by the Commissioner of the Department of Health. I'll mention first off that when lawyers write contracts and when government agencies make pronouncements, they like to put in sort of introductory language called whereas clauses. So this order has 19 whereas clauses, and it cites the president, the governor, the mayor, the CDC, the WHO, Yale University, and then the health department commissioner himself about 6 times. The point being, we're very serious about this. This is very important. And we're going to try to justify all this by putting all of these reasons right up front. And after all that prefatory language, what they've ordered is starting on December 27th, which was 2 weeks from when the order was issued, Workers must provide proof of vaccination against COVID to every covered entity, and that means all workplaces. And a workplace is defined as essentially any place that work occurs with more than one person. So that would include even a vehicle, for example. So anybody who is exposed to coworkers or the public and is working in New York City must be vaccinated. And if they're not, they must be sent home. What does vaccinated mean? It means either fully vaccinated, 2 doses of Moderna or Pfizer, or 1 dose of Johnson & Johnson. If you've had the first dose of either of the 2-dose regimens, then you've got 45 days thereafter, and the employer is responsible for monitoring that and making sure that the second dose is administered within the 45-day time period. Who is covered? It's basically all workers, and then there are some exceptions. The exceptions would include people there for a limited purpose. So delivery people, for example, that would be an easy one. If a patron or somebody wants to use a restroom, that would be another one. So anything that's sort of quick and very limited, you're not going to be obligated to require proof of vaccination. But for everybody else, and certainly anything that's predictable, you're going to be required, including for contractors. So if you're going to have a contractor on your premises, you're required to either have them show proof of vaccination, and you need to take down the information, their name, and check their ID against the vaccination. Or if it's a contractor, you can actually ask their employer, the contracting agency, to do it. So if you contract a plumbing service, the service can provide the proof of vaccination or assure that they've done so. Exceptions, there's a reasonable accommodation exception, which I think by this point most people know are basically twofold. There's a medical accommodation, and there's also religious accommodation, but they're pretty stringent as far as what's permissible. There are, or they have provided information in terms of accommodations and what's permissible for either one. For medical accommodations, severe allergic reaction to one of the vaccines qualifies, or a proven allergy to one of the components in one of the vaccines also qualifies, and that's for a permanent medical exemption. Temporary medical exemptions, if there's the person has had monoclonal antibodies or convalescent plasma in the last 90 days, or certain other medical statuses, if they're undergoing stem cell transplants or certain other forms of therapy, they may be eligible for a temporary medical accommodation. And then perhaps the more tricky or interesting one is religious accommodation, which the New York City order does permit, but it seems that it's somewhat in conflict with what you've probably heard about. Generally, the standard is if there's a sincerely held religious belief, the person may be eligible for an accommodation. The New York City standard seems to be encouraging employers to really test the validity of the sincerely held religious belief, and to basically ask for more information than we've generally been telling people that they should ask for. And they encourage, basically almost interrogate them. For example, has the person taken other vaccinations and previously? And if so, sort of what's different about this one? Generally, we don't get into that kind of stuff in a religious accommodation questioning situation. So those are sort of the real basics. and that part's pretty simple. I guess one other thing worth mentioning is shortly after the DOH order, there was an updated mayoral order on the Key to New York City Act, which doesn't apply to employers, but applies to sort of places of general public accommodation. So essentially, arenas, gyms, things like that. And they're also mandating checking vaccinations for everybody attending any of these public facilities, with certain exceptions. For example, children under 5, and athletes, performers, and people who are not from New York City. So the easy way to look at this is basically everybody's got to show proof of vaccination with extremely limited exceptions. And that's it.
All right, Michael. Well, thank you very much. We really appreciate the overview. All right, last but as always not least is Katie Anderson from Albany. Katie, the floor is yours.
All right, let's get into it. So let's look at where we're at today. Things aren't going well in terms of COVID. We see this spike for the past 4 days. New York State has had a record every single day in terms of the amount of cases that we are seeing in the state. As you can see, we've had cases nearly double over the past 2 weeks. Looking at over the past 14 days, there's been an 81% change increase. And right now, our daily average is right around 17,000 cases a day. That really, the past 4 days, the case numbers have been above 20,000. So we're really seeing a pretty large outbreak of COVID numbers. The vaccine progress, we've seen all of these numbers tick up 1% over the past week. That's good news, except for the 12 and older being 81% fully vaccinated. One thing to note is that the Governor Hochul announced yesterday that people in New York, 40% of New Yorkers who are eligible to receive boosters have done so. This is good news, especially considering what this new variant is doing, which we're going to talk about right now. So looking at these two maps side by side, I know we've been doing this for the past few weeks. I wanted to do it one more time because I think there's some interesting things here. So center in on Tompkins County. Tompkins County right now is the center of one of the largest outbreaks in New York State in terms of, people per capita who have COVID, and it is centered on Cornell University. And Cornell does have a vaccine mandate in place for its students. You are also seeing places where vaccination rates are incredibly high, like New York City, Manhattan specifically. You do have a very high number of COVID cases happening. So what's happening? It's the Omicron variant. So this graph is from the Ontario, the province of Ontario in Canada has a COVID-19 science advisory table. That is their, it is a formal group, but they are an outside group of scientists that have been advising the province of Ontario in what they're doing. Can we go back one slide? Thank you. So when you look at this graph, because I think this is really a fascinating graph about what's been happening with the Omicron variant, you see that before December, basically, we saw that the double doses of the vaccines really prevented about 90% of cases. It was really effective. Then all of a sudden Omicron hits and it drops down. And so now we're looking at the vaccines, the 2 doses of the vaccines are really only preventing 50%. It's less effective than it was at preventing cases. However, it still appears the 2 vaccine doses, and then even more so with the boosters, are effective so far at preventing hospitalizations and ICU admissions, which is really, that's the critical issue here. We can't strain the hospital system. The Omicron variant in the country right now, in the US, it accounts for 73% of new infections. That was the number as of last week. I expect that right now that number is even higher because we've seen how this is just taken off like wildfire. But this group, the Science Advisory Table from Ontario, has found that unvaccinated people are twice as likely to be infected with the Omicron variant, but about 15 times more likely to end up hospitalized and about 25 times more likely to be in the ICU if they become infected. The one thing to note here is that there will be a lag on knowing for sure the hospitalization data. It'll be about another 10 days before we can really accurately see what is happening in terms of hospitalizations. So where does that leave us? In New York, yesterday, the governor announced that $65 million is being allocated to counties to enforce the mask mandate. Additionally, there may or may not be, it's really kind of confusing where this ended up, there may or may not be state inspectors who are coming around and enforcing as well. The governor walked back her comments yesterday that state inspectors would be doing spot inspections, but I do think that state inspectors will likely be around in counties, especially counties where the health department has said, oh, we're not going to be enforcing this, or the county executive has said, we're not enforcing this mask mandate. 40% of eligible New Yorkers have received the booster shot, but like I said before, but the governor has now announced that the state is opening a bunch of new mass vaccination sites for people to go to receive the shot. Many of those vaccination sites are doubling as testing centers. Additionally, the governor has ordered 10 million more at-home testing kits to be distributed for free. 5 million are to be distributed to schools, and there's no plan to close in-person learning. Those 5 million that are going to schools are really intended to cover if one student in the classroom ends up with COVID, what happens to the rest of them. Additionally, the governor did ask the president to invoke the Defense Production Act regarding production of at-home test kits. And as a result, today the president is announcing that they are invoking the Defense Production Act to accelerate the production of tests. The federal government is going to be purchasing 500 million tests, at-home tests, that people will be able to order online, but those tests won't be available until January. And that, yeah, as we can see, we will need them sooner than that, but we have to make do with what we have. Military personnel are also being deployed to hospitals, military personnel with medical, background profession. They will be going to hospitals, and I guess there's a question slide here that I didn't mean to keep in, but with that, Adam, I'm gonna throw it back to you.
Katie, thank you so much. Unfortunately, today we don't have time for questions, but Andy or I will be addressing your questions in the next couple of weeks, so please keep them coming. Here is information on how to contact those of us who presented today. I'll also remind you that the webinar series will continue into next year. One final thing to note, over the past week, the HERO Act was extended a third time. So the HERO Act, as you may recall, on September 6th, the governor designated COVID-19 as a highly contagious disease, and therefore you all had to enact your HERO Act plans. That has been extended now 3 times, this time through January 15th. With that, happy holidays. We hope you all have a great holiday if you celebrate. We will see you next week.